El Paso, Texas. Population 500,000. Voted the safest city in America 5 years in a row. Home of the Chihuahuas baseball team and UTEP, which produced the likes of Tim Hardaway Sr. and the UTEP two-step. Also known as West Texas University. They started the first all-black lineup in the NCAA tournament in history. Neighbors to one of the most controversial sites of modern-day time. And now the new home of Supreme Decisions YouTube channel and podcast. Come on, take the journey with me, and we'll see how far the rabbit hole goes. What's up, people, and welcome to Supreme Decisions Legal Second. Welcome to the video today. Well, I want to thank everybody and each and every one of our donors, and I'm also going to send a shout out to my dude Cedric. I appreciate you. He's the sponsor of today's video, and today I'm going to answer a question. I know I've been saying that a lot lately, but you guys have been having a ton of questions that are very good questions. Now, I apologize for not being able to get videos out this week. Yeah, I've been kind of swamped. But today I want to discuss California v. Emmons. Now, the question that was laid out to me was, does that kind of nullify qualified immunity? And that answer is hell no. Because what we need to understand is, just like I stated in the previous video, or right there, video, qualified immunity is lost through deliberate acts or willful acts and blatant ignorance. And California v. Emmons is one of those cases where it actually illustrates exactly that because of the situation. But it also demonstrates why I constantly say challenge each and every aspect of a police investigation or matter against you. Now, we understand qualified immunity in this case was basically two police officers clearly violated an established law, which is the definition of the loss of qualified immunity. Now, the one thing about it is to give you backstory on this case. Now, generally, I do not do the backstory on whole cases because it has very little to do with application. But the reason I'm doing it today is because it offers an understanding on what the application of other things that I'm saying goes for. Now, again, Officer Craig stopped the man, took him down quickly to the ground, and handcuffed him. Officer Craig did not hit the man or display any weapon. The video shows the man was not in any visible or audible pain as a result of the takedown. Now, remember, I constantly say the officers are liable for your safety. They are also liable for you and your health when you're in their custody. That's what this statement demonstrates. The reason why the verbiage that they use here is what it is because it illustrates there was no pain. But also, if you remember, I think video 8 or 9, where I spoke about literally, video 8 or 9, I spoke about you don't have to receive actual harm for there to be a violation and a police officer be liable. That is what Emmons exercised here. Now, I'm going to go on. Officers helped the man up and arrested him for a misdemeanor offense of resisting and delaying a police officer. Now, again, they're attempting to generate revenue because there was no crime. Because what was he resisting? Their very statement said that there was no resisting. The officer took him down. They handcuffed him. He wasn't screaming, wasn't loud. There was no audible signs of pain or anything. So where did the resisting come in? Marty Emmons sued Officer Craig and Sergeant Toth because you remember, again, I think that was video 11 where I spoke about the supervisors are liable for the actions of their subordinates. Now, we didn't hear anything about Sergeant Toth, but Sergeant Toth is responsible for the actions of his subordinates. What we're going to do now is the case that is going to kind of jump in here is Casella v. Hughes, 584 U.S., and it's a 2018 case. Qualified immunity attaches when an officer's conduct does not violate clearly established statutory or constitutional rights of which a reasonable person would have known. It goes on to read, the clearly established right must be defined with specificity. What happens is now everyone watching this video, you are a reasonable person because you know with specificity of what police can and cannot do. I'm going to say that one more time. You know with specificity, because of the number of videos I have, the number of podcasts that I offer, you know with specificity what the police are allowed to do and what your rights are. Because you remember, it's only the rights man will defend. Because you now know what you can defend and why. And understanding clearly established with specificity. Just like I'm going to go into another video later where I believe a young man had brought up the fact that, oh, a traffic stop is a reason for them to stop you and it's probable cause. Part of that is right. But I'm also going to go deeper into that case that we're going to bring up for that. Because we also know Delaware v. Proud says one's locomotion cannot be stopped without probable cause. And a traffic citation or a traffic infraction is not probable cause. But again, we'll get into that later. Because now what we're going to talk about here is it does not suffice for a court simply to state that an officer may not use unreasonable and excessive force, deny qualified immunity, and then remit the case for trial on a question of reasonableness. An officer cannot be said to have violated a clearly established right unless the right's contours were sufficiently defined that any reasonable official in the defendant's shoes would have understood that he was violating it. Because you remember, I speak about willful acts. Now here's the smack in the face from that. Because we have Owen v. City of Independence, 445 U.S. 622 1980. That last statement, that a reasonable official in the defendant's shoes, that means public, the elected, the selected, and the employee of government would have understood that he was violating it. Now, it doesn't mean that that person was not ignorant of it, because again, ignorance is also a loss of qualified immunity. But a deliberate act is one that is law. But understanding that their guys are not state statutes, codes, and ordinances, but federal law, which means by me saying a lot of times you hear the words officer discretion. That's because they have the option to do something or not do something. They have the option of giving a warning or letting something ride. They are making a conscious choice, which means they are making a deliberate act. They are performing will. Now, with that, officer discretion and Owen v. City of Independence, they are now liable for all of their actions, for they are deemed to know the law. Period. They are law enforcement. If they are not enforcing law, they are violating and losing qualified immunity. And here's why we use those Supreme Court decisions in our complaints when we're writing up our 42 1983s. We have stressed the need to identify a case where an officer acting under similar circumstances was held to violate the Fourth Amendment. Where there does not have to be a case directly on point, existing precedent must be placed the lawfulness of the particular action beyond debate. Of course, there can be a rare, obvious case where the unlawfulness of the officer's conduct is sufficiently clear, even though existing precedent does not address similar circumstances. But a body of relevant case law is usually necessary to clearly establish an answer. This is what we are doing. This is how it's done through application, because when I spoke about Terry v. Ohio, and I spoke about the coverage, the several different aspects, the multiple levels of situational coverage that Terry v. Ohio carries, and then I talk about multiple cases around Terry v. Ohio, because everyone's case is different. Everyone's situation is different. That's why you tailor it to your situation. That's why you're giving a multitude of cases around a multitude of situations. And this is giving you further understanding of why qualified immunity is null and void if there's an action directly against one of the Supreme Court cases that I'm giving you. Because all of these cases are done by situation to set up precedent, stare decisia, and it sets up law, because of the supremacy clause of the United States Constitution and the supreme law of the land, with the federal statutes as well as Supreme Court decisions. We'll go deeper into that later, but I just want to give that to you right now. Keep donating. Let's keep going. Let's keep growing. Until next time, don't forget, we love Cash App, Venmo, appreciate you, Google Wallet, all of those work for me. Let's go.
Do not try and bend the spoon. That's impossible. Instead, only try to realize the truth.
What truth?
There is no spoon.
There is no spoon?
Then you'll see that it is not the spoon that bends, it is only yourself.